Good afternoon to everyone. Let me start by expressing my sincere appreciation for the invitation. It is really an honor to be speaking amongst such esteemed scholars and fierce practitioners. Before I start talking about my actual topic, allow me to give a bit of context. Since South Africa submitted its application in December 2023 before the RCIJ, I've been working on the question what impact the RCIJ's provisional measure order would have on third states, recognizing it wouldn't have much impact on Israel, basically. So my research interest had since been what legal impact this order has on states providing support to Israel politically, financially, and or militarily. As someone who has received her entire education in Germany, I was appalled by Germany's limitless support to Israel. And that's why I've been focusing my academic and practical endeavors on Germany. So in December, I started writing an academic paper to map out the legal obligations resulting from the RCIJ's provisional measures order for Germany on the international and domestic level, and then how to adjudicate those. Unfortunately, I don't have enough time to discuss the findings of this paper, but in brief, I argue that the RCIJ's provisional measures order, concluding the plausibility of genocide, establishes then the necessary evidentiary threshold to trigger state responsibility for third-party states on the international level, as well as to initiate domestic legal proceedings for Germany's provision of political and military support to Israel. So concretely, Germany's state responsibility to prevent genocide under Article 1 of the Genocide Convention, firstly. Secondly, to refrain from complicity in genocide under Article 3, Lit E of the Genocide Convention, respectively under Article 16 of the ILC draft articles on state responsibility. Thirdly, to refrain from rendering assistance to states committing a serious breach of a jus cogens norm under Article 41, Paragraph 2 of the ILC draft articles on state responsibility. And thirdly, to seize weapons exports under the Arms Trade Treaty. For clarification, when I speak about Germany's military support to Israel, I mean Germany's unrestrained governmental approvals of export licenses for military equipment. And when I speak about political support, I refer to public statements by government officials, for example, reiterating that Israel is a democracy committed to human rights and international law, and that any accusation to the contrary were absurd. Chancellor Scholz also said, I don't think the calls for an immediate ceasefire or a long pause are right. The German government voted against the adoption of UN General Assembly resolution demanding immediate humanitarian ceasefire. Germany's declaration to intervene before the RCIJ on behalf of Israel, as well as, of course, resorting to the most extreme measure of pausing funding to UNRWA. That just was for clarification as to the term military support versus political support. In parallel to mapping, me and some colleagues created a consortium of like-minded lawyers in Germany in order to take legal action domestically. Based on the ICJ's order, we pursued basically two legal avenues, one criminal and one administrative one. The first step we took was to submit a criminal complaint to the German federal prosecutor in February, aimed at opening a criminal investigation against German office holders on aiding genocide. By authorizing military weapons exports, firstly, and secondly, defunding UNRWA. Here we argued that the ICJ's order met the low evidentiary threshold of initial suspicion, which is required for opening criminal investigations. I'll talk a bit about the technicalities of that criminal complaint. So, German criminal law criminalizes aiding acts of genocide. Two conditions must be met for that. Firstly, the commission of genocide as a principal offense. And secondly, the intentional and causal provision of aid to the principal offense of genocide. Regarding the first condition, the commission of genocide, we argued that the actions of the IDF amounted to the material elements of genocide, and referenced statements by several high-ranking Israeli officials referring to Palestinians as human animals, as we all know, or ordering a total siege, which would amount to the specific intent to destroy a protected group in whole or in part. It is important to note here that at the stage of opening criminal investigations, the evidentiary threshold is relatively low and requires merely sufficient reason to believe that a crime has been committed. So we argued here that the plausibility of genocide concluded by the ICJ order should be sufficient at that stage. Now, regarding the second condition, we argued that the provision of aid must be seen in authorizing arms exports licenses or failing to revoke them, as well as in providing political support. German criminal law requires the aider to act with a double intent to assist. So intent for the provision of aid and intent regarding the commission of the principal crime, here genocide. While the first intent is relatively clear, the second one might be a bit more challenging at first glance. However, it is sufficient for the assumption of intent that the aider recognizes the essential features of the principal crime, in particular, its unlawful nature and direction of attack, meaning the aider does not need to know all the details. And we argued that post the ICJ order, which concluded the plausibility of genocide, such knowledge should be assumed by German office holders. Lastly, German law requires causality between the aiding act and the principal crime. Which specific degree of causality is, however, disputed in the context of aiding. Relevant case law assumes that a strict causation is not a prerequisite, meaning support given to the principal perpetrator would constitute aid, even if such support was not the conditio sine qua non for the commission of the principal crime. German criminal law acknowledges the concept of moral support, meaning it is sufficient that the aider contribution merely encouraged the principal crime. We argued that it is safe to assume that the statement by the German Chancellor Scholz in October 8, where he guaranteed Netanyahu any assistance, including expedited authorizations of weapons and voting against a ceasefire resolution in the General Assembly, has further encouraged Israel to continue its war on Gaza without changing anything. The German federal prosecutor has unfortunately not responded or acted in any way to our criminal claim. We just submitted a request last week and hope to receive an answer soon. Just one last point here. Failure to investigate despite obtaining knowledge of a suspected offense would constitute a violation of the principle of legality and possibly indicate political unwillingness. Now, let me turn to the administrative complaint to deny authorization of war weapons exports. In April 2024, so 2 months later, we filed an application for a preliminary injunction before the administrative court in Berlin against the German government. The aim was here to get the court to order the government to deny the authorization of war weapons exports to Israel. To our disappointment, the application was denied on June 11th. But let me still talk about some aspects of the complaint. Procedurally, we faced the issue of standing because German law denies public interest litigation in the area of weapons exports, which is a fundamental difference to the Dutch case, where basically two NGOs were the plaintiffs. Instead, German law requires that the plaintiff is directly affected by the administrative act, so the authorization. That means only people who currently reside in Gaza have standing. Here, however, comes the second legal issue, procedural legal issue, namely, to which extent do foreigners who reside outside Germany have standing before German courts? So we took our chances and filed the application on behalf of 7 Palestinians who currently still reside in Gaza and argued that the German government has a constitutional obligation to protect life, which binds the executive, even extraterritorially. This argument had been accepted once previously and was confirmed in our case. So that confirmation was a success. On the substantive level, we based our claim to order the government to deny authorization of war weapons exports to Israel on Article 6 of the War Weapons Control Act, which basically mirrors Article 6 of the Arms Trade Treaty. This provision prohibits the authorization of war weapons exports if there is reason to believe that such exports would violate or endanger Germany's international legal obligations. So there are basically 3 elements. Firstly, the weapons in question have to fall under the scope of the law. Second, a violation or endangerment of an international obligation. And third, the mental element of having reason to believe. Regarding the first requirement, in 2023, the German government authorized weapons exports to Israel totaling 20 million a great portion were exported after October 7th and are categorized as war weapons under the War Weapons Control Act. And in early 2024, further arms exports to Israel were authorized, amounting, however, only to 32,000 euros. And those also fall under the scope of the law. Regarding the second requirement, we argued that Germany's export of war weapons to Israel post the ICJ order would at least endanger Germany's obligation to prevent genocide under the Genocide Convention, its obligation to refrain from rendering assistance to states committing a serious breach of a preemptory norm under the ILC draft articles on state responsibility, its obligation to deny authorization of weapons exports because there is an overriding risk of serious violations of human rights under the Arms Trade Treaty, as well as under EU law, whereby authorization of weapons exports must be denied if there is a clear risk of internal repression. And then regarding the third requirement, reason to believe, we argued that the plausibility of genocide established in the ICJ order equates to the relatively low reason to believe threshold. Now, the court denied, as I said previously, our application because the government said it had changed its practice of authorizing war weapons to Israel and is no longer authorizing export licenses, and therefore the application is moot. Let me quickly tackle two positive and two negative takeaways. The positive one is that it seems that our application was another step besides, of course, Nicaragua's application before the ICJ, that ultimately led to a change in Germany's practice, which was the goal. A second positive takeaway is that the right to life binds the German government extraterritorially, which results in procedural standing in such claims. Negative takeaways. It is almost impossible to win these claims because the plaintiff has to prove which applications for weapons exports are being under consideration or even granted. And that procedure is not open to the public knowledge. So only parliamentarians actually have the right to be informed upon request. So we had to base our application on the request of one left-wing parliamentarian who received a response from the government in January. The government just responded to our claim by saying that they had no longer been authorizing licenses since then. So it is a very intransparent process, and as an individual or as a plaintiff, you do not have the right to be informed of applications for war weapons exports. And a second negative takeaway is that these authorizations, once given, can be used up to 2 years. So weapon exporters can still export for quite some time. Thank you for your attention, and bye-bye.